Please be seated. We'll hear argument in 2384, In re Christianson Air Conditioning and Plumbing, LLC.
Ms. Livingston will present argument for the relators. Relators have reserved 5 minutes.
Mr. Chief Justice, and may it please the court. This case is about whether overlap between jurisdictional discovery and merits discovery operates as a blanket prohibition under Rule 120A as to the areas of overlap. We say it does not. And this court, in its decision in Bland Independent School District versus Blue, has likewise suggested that it is not a blanket prohibition. So the question is, to what extent is Rule 120A discovery, can it permissibly overlap with the merits? This case is ultimately about, or comes down to, how we protect the due process interests of specially appearing defendants, while at the same time permitting plaintiffs a reasonable opportunity for discovery of jurisdictional facts. It seems that this problem of overlap arises mainly in cases of specific jurisdiction, and that problem is especially acute when there is a very strong relationship between actionable conduct and the theory that the defendant targeted the forum. That's the case here. That's our jurisdictional theory, that JANA Corporation had designed the product here with sales in the forum in mind. If the rule were, as the Court of Appeals said, and as JANA has argued, that Rule 120A discovery of overlapping facts is off limits, that would kill specific jurisdiction for a significant swath of cases. So that can't be the rule. Now that's the easy step. The hard question is, what is the extent of overlap, and are there some useful guiding principles that this court can give trial courts in deciding what are facts essential needed to oppose a special appearance? The first thing I would say is that there ought to be a clear presumption that we should get discovery if there's overlap. If it's relevant, we should get it. If, in the language of this court's opinion in Doe, if it's directly relevant, we should get that discovery.
Is there a difference between relevant and directly relevant?
That is a good question. It's unclear to me exactly what Doe meant by using the phrase directly relevant.
Well, what if we look at the summary judgment continuance cases for context on that?
That's right.
And if we do that, isn't directly relevant a narrower set of questions than anything you would get in discovery, right? That could tend to lead to the discovery of admissible evidence doesn't sound like directly relevant.
That's how I read that language in Doe, that it wasn't just the reasonably calculated to lead to the discovery of admissible information, but it was that narrower category.
And so if that's the case, then what does that mean for something to be directly relevant? Does it need to go to one of the elements that you have to prove in order to establish specific jurisdiction? For example, does it need to show that the product was designed for the market, or that there's a relationship between the relatedness part of the does it need to go to one of those prongs, or part of the stream of commerce test, something like that?
I think the answer to that has got to be yes, if that's going to be the standard, and if that's going to be sort of the judicial gloss or the extra explanation that helps the trial court unpack what facts essential means out of Rule 120A. On the other hand, I would say that directly relevant can't narrow out and exclude discovery of circumstantial evidence. And here's why. Most specially appearing defendants are not going to admit that they have designed something for the forum or that they meet the relatedness test. And I think in large part, circumstantial evidence is how we prove a lot of those things. And so I don't think directly relevant can exclude that. But I do agree with you that it is a narrowing. There are some alternate formulations we've seen in some of the cases. Like I've seen, for example, it needs to, a discovery request needs to, quote, primarily relate to jurisdiction. And I would try to steer the court away from that particular verbal formulation. Because I think, especially when we've got that strong relationship between actionable conduct here, which is, designing a product, and what we say constituted purposeful availment, which was designing it with sales in the forum in mind, those sit almost right on top of each other. And so how is a trial court to decide when an inquiry relates primarily to one versus the other? I think it becomes a little difficult. Let's just say that it's 51% versus 49% because they've got to pick primarily which one it primarily relates to. If we've got that close of a relationship between actionable conduct and, let's say, additional conduct, and a judge picks 51-49, if it's 49% related to a jurisdictional inquiry, that's a significant relationship. And I think it's directly relevant if we're going to use the language from Doe as well. And so I think that the primarily related to verbal formulation is ultimately not going to be particularly useful for trial courts. On the other hand, I think if we're just to stick with the directly relevant language, that arguably could result in some inquiries that are a little too broad and might result in inquiries that aren't respectful enough or compatible with the due process interests of a specially appearing defendant. As I said in my opening, if it's relevant, I should get it. Or if it's directly relevant, I should get it. Well, how relevant is it? It can be directly relevant, but at the end of the day, it might still be a little, tangentially relevant. If we think about a Venn diagram, right? Maybe the area of overlap is slender in the middle. Maybe the area of overlap is actually quite large. Where are we if something's directly relevant to jurisdictional inquiry? Is it kind of in the middle? Is it closer to jurisdiction? I think we need to help the trial courts sort through that a little bit more.
What would you add to directly relevant?
Yeah, if I were writing it, I think I might suggest that trial courts, I think we could do it under the facts essential language in Rule 120A, because I think the word essential carries some heavy freight there. I think that it covers a lot of territory, and if I were sort of writing some judicial gloss on top of Rule 120A, I might say we could suggest that trial courts consider whether purely phased discovery or segregated or bifurcated discovery, jurisdiction and merits, that they consider whether it's feasible, fair, and efficient. Now, I think there's some sub-reasoning under each one of those, but let me start with the last of those and put an asterisk on efficient. In candor to the court, I don't think we can properly consider the full range of efficiency considerations and still be protecting a specially appearing defendant's due process interests or due process rights. I think it's a more limited range of efficiency considerations. Let me give you an example. Rule 120A seems to promise that the special appearance is going to be resolved early in the litigation. So I think a trial court could probably consider whether allowing a particular discovery inquiry that happens to overlap with the merits is somehow going to hamstring moving through that discovery process so that the special appearance can be had and resolved. Another efficiency consideration that I think could be underneath sort of the more narrow, appropriate efficiency considerations for, facts essential might be, is the jurisdictional inquiry in question pretty close to the middle in terms of overlap, or even closer to the jurisdiction side of the overlapping area, such that we should be concerned about plowing all the way through the special appearance hearing, which sometimes end up being like little mini trials with evidence and the whole thing. And then the legislature, of course, has granted an interlocutory appeal as of right, win, lose, or draw on that. And should we be concerned about a pretty legitimate jurisdictional question, discovery inquiry, that, is going to cause the case maybe to be reversed after all of the special appearance hearing has, gone and the evidence has been done? So I think those are the kinds of more limited efficiency considerations. Feasibility in terms of saying no to an overlapping inquiry, I think that one doesn't take too much unpacking.
On the overlapping inquiries, how is the discovery that you're seeking in this case directly relevant to the jurisdictional question without imputing a co-defendant's context with the forum to the specially appearing defendant?
Right. And
In other words, the specially appearing defendant in this case didn't sell the product in Texas, right? Didn't manufacture the product, didn't sell it in Texas. So how is the discovery that you're seeking directly relevant without sort of saying, but you worked with a defendant who sold in Texas, and I think we have cases that say you can't impute jurisdictional context in this kind of analysis.
Correct.
One's by
correct.
a co-defendant.
Correct, right? It's got to be the defendant's own forum-related activity. And some of your question is going to bleed pretty heavily into the merits where, this court has said we're not going to consider sort of liability defenses and things of that nature at the special appearance phase. That's not what we do. We've had plenty of cases, Michiana disapproved of several Court of Appeals cases that said, that had considered that kind of a thing, and this court's repeated that in a number of cases in Moncrief and, TVS Teca and a number of others. So the contention, again, bleeds over quite a bit to the merits, is that this defendant, our contention is, and we haven't gotten discovery of that. I don't know if we can say that on this record at this point, right? But it was knee-deep in the entire process, and we think that there is still an argument under the common law and under this court's decisions, and it's a complicated legal analysis that would allow us ultimately get to a valid specific jurisdiction theory, right? But at this phase, but again, that's going to bleed over into a liability question, so we have to pull back a little bit. Like in TVS Teca, some of those defendants said, especially appearing defendants said, hey, we don't have enough control, we can't even be liable. And this court was like, okay, that's fine, but that's not before us at the special appearance phase.
So the merits theory is that they were basically part of the design team, if you will, and that's going to be enough for liability, and that's what you're saying we can't look at this stage? Correct.
And on this record, I don't know that we can, say much more than that. We haven't gotten merits discovery to actually just, ferret out the full extent of all of that.
Maybe it would help to look at the specific inquiries here and see what's directly relevant. For example, number 18, JANA's studies, text, investigation, and assessment of PE and PECs generally. Presumably that includes products not made by NIBCO, because 17 is more about this particular product. So how is that directly relevant to the jurisdictional inquiry?
Right. It's the end of that inquiry. It's the field conditions in Texas. And the reason we've got to restate it between 17 and 18 the way
But even if it's for Texas, then if it's not this product, then how is it directly relevant to the jurisdictional inquiry?
Yeah, I think directly relevant might cause that one to be narrowed some down, and tailored a little bit more to be more like 17. But it's, part of the problem here is that JANA has contested sort of everything and said it never gave one thought to the field conditions in Texas when it was doing its work in connection with completely reformulating this product and redesigning it. And they've stood on that. And so we've had to come up with various verbal formulations. And the other thing to think about is that these are topics for deposition inquiries. These are not specific deposition questions. Like if I went to a deposition and I asked a question and counsel instructed don't answer that, and I asked the court reporter to certify that question, and then we went down. Those would be very particularized inquiries. So by their very nature, these are a little loosely stated. So what they're trying to drive at is, because Jana keeps on dancing around its role in connection with this and what its knowledge was and whether it had an intent and purpose to serve the Texas market and whether.
But, so one of the topics is Jana's knowledge of problems and failures with NIBCO's PEX pipe. How is that relevant to jurisdiction? Whether Jana had knowledge of problems and failures with NIBCO's pipe. How is that relevant to the specific jurisdictional question?
So it's knowledge with the pipe, but it's the pipe at issue in this lawsuit.
Right.
Right, at the end. And the problem here is, so what Jana does is it comes in, people have problems with their pipe, they hire Jana and they say, we're having problems. Jana comes in and fixes these issues. That's how that's what Jana sells, okay? And so, but Jana, again, and we know NIBCO, NIBCO's largest customer was our client, Christianson in Texas. We know that Christianson was having problems with this PEX, and we know it was failing in some Texas field conditions. But Jana keeps on dancing around it. And so what we're trying to get at is Jana's knowledge of the problems with that PEX at issue in this lawsuit, and whether its work on that reformulation project was done in anticipation of continued sales in Texas, and that's essentially how it's relevant. It does look a little broad. If this were an interrogatory or a request for production, I might be the first person objecting to it as being overbroad. But again, these are topics, and I think a trial court has a number of tools available to it to deal with, deposition topics loosely stated like this. And these were a product of counsel trying to confer in advance and come up with kind of a meeting of the minds, so we weren't wasting our time when we all flew up to Canada. And that was the rub, and this was the product of that, so we could put something in front of the trial court.
Any other questions? Thank you, Ms. Livingston. We'll hear from the real party.
May it please the court, Mr. Ziegler and Mr. Bell will present argument for the real party and interest. Mr. Ziegler will open with the first 14 minutes.
Mr. Chief Justice, members of the court, may it please the court. I will address two of the three arguments Jana advances. The first, whether the Court of Appeals properly applied the law and whether the Court of Appeals properly got the law right and applied the law. So those two issues I will address. Mr. Bell will address the right of this realtor to bring a petition for mandamus to this court, which we believe they do not have that right. So we have divided our time accordingly. The Court of Appeals properly applied the law here. Jana does not see that this court and the jurisprudence in Texas is missing a rule or test. Yes, there is a vacuum between the time that In re Do was decided and today, and some of the intermediate Court of Appeals decisions that have come down in the meantime. And there is not a specific case from this court that deals directly with solely specific jurisdictional discovery question, because In re Do, of course, was a petition 202 case.
Well, let me ask you about your opposing counsel's formulation and the directly relevant test from Doe, which you also seem to embrace Doe. So is that the proper test? And she even suggested that it might be more favorable to you than Doe in considering some of these other factors. Do you agree that's the proper test, or are you advancing a different test?
Jana advances the directly relevant test.
Okay, so you're not defending the Court of Appeals holding that it has to relate exclusively to the jurisdictional question.
We are as well.
But those are two different tests.
Well, I believe they're one, Your Honor, and here's why. directly relevant means directly relevant to the specific jurisdictional question. We have a rule of procedure, not Rule 193. We have a specific rule of procedure that exists for jurisdictional discovery, and because 120A3 has its own language, and we have case law, including case law from this court that's interpreting that language, and then we have tests that go to what a special appearance is about. We believe we have the test necessary for trial courts to make the determination. The reason that directly relevant and exclusively related to jurisdiction are in harmony is because the only question should be jurisdiction, directly relevant to jurisdiction, but not anything else.
Where do you get that, but not anything else?
From Rule 120A. 120A3, facts essential. Facts essential, if you look at the fact that we have that rule in and of itself, is very guiding to this court and the courts below. Speaks volumes. Looking at the plain language of the facts essential. Essential facts to justify opposition to the special appearance.
But facts can be essential to two different issues.
Yes, they can, but remember, this is a rule regarding special appearance and jurisdiction. So we're not talking about Rule 193, so we're not talking about, as counsel would have, Christianson wants to have it broader, and the reason that they do is from the very beginning, Christianson has desired to conduct a dual path of discovery before the special appearance was decided. They wanted merits-based discovery and jurisdictional discovery. We can't have both. The reason we can't have both is we need to protect the due process rights of the non-resident defendant, in particular the non-resident defendant who's from Canada, so from another country, and that is who Jana is.
So let's say if we don't adopt that exclusivity requirement, but we do go along with the directly relevant, how would your test differ from your opponent's test?
Okay, so it would be applying the test and approach that the Fifth Court took in In re Pearl. Because if you follow that case, and it's a 2020 case, didn't reach this court, of course, but you see the rendition of, here's the rule, 120A and facts essential. Here's how we get to then minimum contacts. Here's the test for minimum contacts. And of course, the primary question in minimum contacts is purposeful availment. And we have a test from this court's Cornerstone Health Management case opinion explaining what the three factors, the three purposeful availment factors are. You look at the discovery question, here deposition topics, but in Ray Pearl they were dealing with interrogatories and with requests for production. You look at those questions through the lens of the purposeful availment factors. So Jana's contacts, Jana's activities, not, as was properly raised by Justice Bland, we're not talking about imputing NIDCO's activities. That's impermissible. Jana's activities directed to, aimed at Texas, so not sitting in Toronto with Jana assisting perhaps NIDCO with the formulation or reformulation, not designing, but as a consultant.
But I agree, if Jana had a financial interest in a Texas sale of the product, that might constitute evidence that could be used in opposition to a special appearance.
Well, I don't agree with that plain statement, because with products, okay, we're talking about products that are sold, manufactured by, designed, manufactured by NIDCO, distributed by NIDCO, marketed by NIDCO. None of that, of course, as is undisputed in this record, none of that applies to Jana. But Jana having an incidental benefit, so there may be indirectly money that comes to Jana by way of a sale of a NIDCO product, that wouldn't be enough. But that's not this record. This record is Jana serving as a consultant getting paid for its consulting fees, not for the sale of products. That's not been developed here. But
No, but they were
Justice Bland,
designing the product. They were
Pardon me?
designing the product or redesigning the product so that it would not, so that the problems that arose would not in the future.
The evidence in the jurisdictional evidence does not indicate designing. It
But
is
isn't that a merits
assisting.
question? Whether you were a designer or not for purposes of products liability law, isn't that a merits question?
It is a merits question.
Okay,
And
so-
it would be, so you would not, and so, which is where I get back to directly
But how
relevant.
can you say you're not a designer if we can't decide that question yet?
Well, the question related to, well, if you are designing, that's not in the record, but getting to whether or not we're a designer, and if you look at the questions here, and looking at these questions through the lens of the 120A facts essential and the purposeful availment factors, as Justice Bland was asking about the third factor of the purposeful availment factors, is it enough that Jana's receiving some financial benefit, a sale of a product? Well, that is getting to a question about whether, regarding the deciding of the special appearance, but whether or not Jana is a designer is, that in and of itself is not a question for specific jurisdiction. It has
Well,
to be
except
Jana's.
that insofar as it's part of the stream of commerce plus test, right?
Right.
And so why, for example, wouldn't topic number 17 be relevant to that? If Jana is studying and investigating and assessing as it relates to the performance of this particular pipe in field conditions in Texas, why wouldn't that be directly relevant to whether by designing, assuming that you did, that would show an intent to serve the Texas market?
So it's got to be Jana's activities.
Right, and that's
Directed
what
to
it says,
Texas.
studies, tests, investigations, and assessments.
Yes. Of that particular product, and then, of course, 18 is generally PEX and PE products, so not NIBCO product, but as the rest of the topic goes, in field conditions in Texas. But that's, and very importantly, in field conditions in Texas, that's not Jana directing activities aimed at Texas. It is about Texas. It is not directed to Texas.
So
That is the
if-
test.
If Ford had somebody design the Pinto engine, and it was gonna go to all the states, and somebody, in one state, somebody hits it and it blows up, then are they not seeking to serve the market in that state because it wasn't designed specifically for that state?
Well, the question here is, the test is, what are Jana's activities directed to or at Texas for a beneficial relationship with Texas? That's what we're saying the test would be. And Jana is not, in this record, in a position of NIBCO. Okay, NIBCO's designing of the product.
Okay, but
That's
how can we
imputing
decide
to-
that again at this stage? If, I know you're saying they designed it and you didn't, but if that's I'm a little lost if you're saying we can't get into the merits and decide that question.
Well, you can, if that's the question, but you have these specific topics before you, and these specific topics go to Jana's activities that are in Toronto, but then the topics go towards NIBCO's activities, NIBCO's design. So recall, we have from the opinion, from the lower court, from the third court, that there are certain undisputed facts, and there is no dispute that Jana did not make, market, distribute this PEX product at all, let alone to Texas. So absent that, what is directly relevant in the context of jurisdictional discovery? And so when you do look at what Christianson is able to inquire of in the remaining topics, they have plenty of those topics that have been afforded to them.
That's a good point. I wanted to ask you about topic 19 specifically, because it seems like it's very much like topic 17. That topic 19 is Jana's participation in studies, tests, investigations, and assessment of the performance of plastic tubing in Texas. That seems actually broader than 17. So what should we do with that?
Oh, it's not before the court, so that.
Well, I mean, I have it in the record that it was.
I do see that. I do see that, and we are here on, of course, a petition for writ of mandamus from the third court. And the petition of writ of mandamus is narrow to the specific topics in question. And now we only have 6 that we are dealing with.
But is it an abuse of discretion to allow discovery on this topic if it's narrower than a topic that is undisputedly going to be allowed?
Your Honor, I was not at the Court of Appeals level arguing to the third court, and I was not in the initial special appearance hearing, and there were agreements reached by counsel, or attempts to reach agreements between counsel. I wasn't involved in those. But what I can tell you is, in arguing the 6 that are before the court, these 6 are out of bounds. Obviously, 2 of the 8 that the Court of Appeals disallowed, 2 of those, Christianson has agreed that those are out of bounds. They're not even bringing to this court. So I'm having trouble answering your question, and I can tell you that I may have trouble with that specific question, but it's not before us. The other questions, however, do not get to Jana's activities directed to Texas. Jana's activities with respect to design, manufacturing, sale, they're not inquired here. They're attempting to get to merits-based questions under the guise of specific jurisdiction discovery because, of course, there is the operative facts elements of establishing the substantial connection between the non-resident defendant, the forum, and the facts in the litigation. But the facts in litigation are really just guiding context. That's not the thrust. The thrust are the 3 purposeful availment factors. That's the test. Applying those factors with the plain language of the rule gets this court and the lower courts what they need to make this decision.
Any other questions? Thank you, Mr. Ziegler.
Thank you.
Bell, we'll hear from you.
May it please the court. As has long been held by this court, the second prong of the mandamus inquiry is whether the relator has established that they have an inadequate remedy by appeal. In this case, the relator has an adequate remedy by appeal from the special appearance determination in this matter. They have argued in their brief that they're not required to meet this element, and I don't think that's an accurate representation of the case law here. For that proposition, they cite Scott versus 12th Court of Appeals, and as Justice Hecht's dissent in that case points out, the court merely skipped over that factor. It didn't hold that just because you're appealing a mandamus from a court of appeals, you get to skip the adequate remedy by appeal factor. So if we move to the remaining arguments, we then look to see if the relator has established that there is no adequate remedy by appeal, which requires us to look at what adequacy means in re prudential and whether or not they've met any of the exceptions that stand out in Walker versus Packer. So in this case, if we look at the in re prudential factors, adequacy just means whether you weigh the public and private interests, costs, and benefits of mandamus versus waiting for an appeal. I think in this case, one of the key reasons that waiting for an appeal is the better way to go is because of the fact that we're dealing with deposition topics. And so from these deposition topics, what the trial court is still going to have to do once this deposition goes forward is determine whether or not certain questions asked at the deposition that we may have instructed our clients not to answer fit within those allowed or disallowed topics.
But if the trial court is applying, and if we decide that the Court of Appeals gave the trial court the incorrect test to apply to those specific questions under these topics, then how is that going to be useful exercise for the trial court to go through under the Court of Appeals test if we think it's erroneous?
Yes, Your Honor. So I believe that there's a way that this court can issue or give guidance on the proper test, and I don't think that the proper test would change the result of the Court of Appeals. This court has the power to restate or clarify what the law is for the scope of jurisdictional discovery while also denying mandamus. And so it's done that 2 specific times. It's done that in In re Smith Barney, and it's also done that in re State Farm Lloyd's. And in those situations, in Ray Smith Barney, it did that to overrule a venue precedent that the trial court had been bound to follow. And then in the other case, this court issued guidance on electronic discovery and the test that a trial court needed to use to craft guidelines about what electronic discovery was appropriate, both times denying mandamus in issuing those rulings while still clarifying the test.
Because there was an inadequate remedy on by appeal, or because there was an adequate remedy by appeal, or was there another reason for denying mandamus relief in those cases?
In those cases, I believe it's because it's then the trial court gets an opportunity to go back and get it right.
Okay, so is there any case where we said that there was an adequate remedy by appeal, but we nevertheless wrote on the merits?
I can't think of one off the top of my head, Your Honor. But in this case, following that guideline or following that practice would have certain benefits in which the trial court would have the test once this deposition does go forward to apply to those particular questions that flesh out these topics. I think under any test this court decides to issue today, these topics are overly broad and not narrowly tailored to the jurisdictional inquiry. Narrow tailoring is a requirement to avoid overbreadth of any basic discovery issue. And the only thing that's really unique about the posture of this case is that it's the third court that found overbreadth, not the trial court. So finding that 6 of 30 deposition topics were overly broad or were improper is not the kind of exceptional issue that usually warrants mandamus review. Plus,
Suppose the Court of Appeals had ordered that all the discovery go forward. Would you be continuing to say that there was an adequate remedy by appeal if you had been ordered to produce the witnesses to talk about every topic?
no, Your Honor, but I believe that's because the case law draws a distinction between a court ruling that requires you to participate in discovery that's legally outside the bounds of permissible discovery, especially here because that violates Janus due process rights. So the law is clear that where a trial court or another court orders discovery that's outside the bounds of permissible discovery, you have a remedy by mandamus because you can't put the toothpaste back in the tube. You can't, put the genie back in the bottle. It's
but
different.
Don't our cases also say that you have mandamus if you can't make the requested discovery part of the record?
Yes, Your Honor, but I think that mitigates towards both parties in this case because addressing the topics by mandamus is preventing development of the specific questions in the record. For example, even though these 6 topics have been denied, they can ask questions that arguably relate or have a good faith basis based on the other facts developed by the testimony during the jurisdictional deposition. Then the trial court gets to make a determination whether those questions fall not just within categories, but within the permissible bounds of discovery using the test this court has made. So I believe saying that the ruling prevents the development of the record is not quite accurate in this case. I think the record needs to be developed by taking the deposition, but only with a prospective mandate on the clearly legally allowable questions. What Jana was faced with at the trial court was 6 or more areas, 9 areas of inquiry that it contended the court had prospectively told the relator, you can ask any questions under this topic, and we would not have had a good faith basis on which to instruct our client not to answer because we had a court ruling saying they had to answer those questions. Our only remedy at the trial court level was to go seek a mandamus, saying that that broad mandate to answer questions was outside the scope of discovery. It's different when you're arguing over breadth because then you have a fully developed record on appeal. The judge has been able to look at specific questions, and then the court looking at the special appearance issue is going to be able to not only look at the ruling on those questions, but is also going to be able to do a harmful error analysis on the lower court's ruling in reaching the special appearance decision. So to conclude, I think the full development of the record is the best outcome for all of the parties, where a court of appeals can look at all of those factors in a fully developed record in making these determinations.
Any other questions? Thank you, Mr. Bell.
Thank you.
Ms. Livingston, I believe you have 5 minutes.
Let's just start with where we left off with the adequate remedy by appeal issue. The rule in Scott versus 12th Court of Appeals and other cases like that from that sort of Walker era, those have continued through today. In the Panda Power Generation decision earlier this year, Justice Busby got footnote 13. She cites a couple more modern cases in which this court does exactly like it does in Scott. It doesn't exactly tackle the issue that Justice Hecht, then Justice Hecht, now Chief Justice, had mentioned in his dissent in Scott, but that is the approach that this court still takes to today. which is if the Court of Appeals grants the mandamus, you don't separately ask whether the remedy on appeal is adequate when you come up here. Be that as it may, I still think that Walker v. Packer and the language that Justice Busby, you were asking about, when you can't make something missing discovery part of the record, and when something is, you can't get discovery and it goes to the heart of an inquiry, that would have shown back in the Walker day adequate remedy by appeal, and I think it fits comfortably within the prudential balancing test, and this court's more modern jurisprudence and weighs very heavily in favor of granting mandamus in this instance, or reviewing this case by mandamus. Let's talk about the jurisdictional inquiry. Justice Busby, I think you were asking about number 19 and whether it in the specific list of topics attached to the trial court's order, and whether it looked similar to or even broader than some of the other topics, to the extent that a non-challenged topic by Jana at the Court of Appeals would have allowed broader discovery. That would suggest that the Court of Appeals abused its discretion in granting the writ as to these other topics that seem similar to it. What I can tell you is that Jana perceived that there was something about these particular 6 inquiries plus the other 2 that we decided to jettison at this court, primarily because I thought they could have been more narrowly tailored, and if more narrowly tailored, they would be subsumed within the 6 that we have here. Jana certainly made a fuss about those topics, and so from our perspective, what our read on that is when we go to take these agreed upon jurisdictional depositions that are going to happen anyway, right, as to the other topics that Jana didn't challenge. When we start asking about the unchallenged topics, if there seems to be some overlap between those and the ones the Court of Appeals, as to which the Court of Appeals granted writ, Jana's going to point to the grant of the writ and say, you can't get that. To the extent there's overlap, these curtail the others. And so I think that's, it's an interesting question how you read those 2 together. I agree that there's a little looseness between the ones they challenged and some of the others, but that's...
Talking about this in broader terms.
Yeah.
How do you respond to the respondents' argument in their briefing that says that under the rule that you propose, any plaintiff could send a full list of merits discovery and then add the words at the end of the question, for products in Texas or under conditions like those in Texas, and turn those into jurisdictional inquiries?
I think that's when it gets back to sort of this test that I was suggesting might be... How
would you narrow it so it wouldn't do that, if that's not what you're advocating? These
are all on a case-by-case, as you know, all the discoveries on a case-by-case basis, and so that does become tricky. And I think that, under the fairness sort of consideration, there are a bunch of tools the trial court is going to have to it, and, have available to it. I think some of those considerations would be, certainly whether discovery to date is already adequate, what's the burden on a defendant, what is the degree of relevancy of that, and that's where we get into, if the area of overlap is broad, where in that area of overlap is it? And I think the trial court could, based on the needs of the case and what contentions the other side is making and whether they are controverting these issues and putting them at issue. And that's one of the things that the federal courts look at, is whether the defendant has put something at issue, and that gives rise to the need for jurisdictional discovery. And I think that's certainly a consideration when taking into account the needs of the case. And the other thing the trial court can certainly look at is this is one of several products defendants in this case. Merits discovery is ongoing as all those other products defendants. So in this particular case, the risk of some sort of abuse by using Rule 120A as some kind of ruse to get merits discovery is a little bit lower, certainly in this case. And I think that's the role of the trial court's discretion and judgment over all discovery requests, including 120A discovery requests.
Any other questions? Thank you, Ms. Livingston. The case is submitted. That concludes the arguments for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.